Welcome to our Israel-Palestine podcast, a project by graduating high school students from Berlin-Neukölln, home to Germany's largest Palestinian diaspora, and a second home to many young Israelis. Israel and Palestine are painfully present in our district and in our schools. We've spoken with historians, legal scholars, trauma researchers, and educators, some of whom are world-leading experts to better understand this ongoing conflict. Our approach has been multi-perspectival. We don't aim to resolve controversies or contradictions, but to hear different perspectives. Human rights and international law are the foundation of responsible multi-perspectivism. Can we learn to listen and hold conflicting truths at the same time? Find your own answers, or better, questions. Are you ready for the discomfort of learning? Welcome to a new special episode of our Israel-Palestine podcast. I'm Yusuf. Thank you for joining us today for an important conversation. We're privileged to be joined by one of Israel's and the world's most respected scholars of international law. We are grateful to welcome Professor Eyal Benvenisti, Professor of Human Rights at Tel Aviv University's Faculty of Law. He recently returned from the University of Cambridge, where he held the Whewell Professorship of International Law. Thank you so much for being with us today.
Thank you for having me.
Professor Benvenisti began his academic career at the Hebrew University of Jerusalem, serving as Hersch Lauterpacht Professor of Law, then moved to Tel Aviv University as the Anny and Paul Yanowicz Professor of Human Rights. From 2016 to 2024, he was the Whewell Professor of International Law at the University of Cambridge and directed its Lauterpacht Centre for International Law. In 2024, he returned to Israel and resumed his professorship for human rights at Tel Aviv University and will be teaching at Yale Law School this fall. Professor Benvenisti has taught widely across the US and Germany, including at Harvard, Columbia, Michigan, Pennsylvania, at the Hague Academy, the University of Toronto, the University of Hamburg, the Max Planck Institute of International Law in Heidelberg, and as a Humboldt Fellow. His research spans international law, humanitarian law, the laws of occupation, constitutional and administrative law. Among his seminal works are the International Law of Occupation and the Law of Global Governance. In 2024, during one of the most high-profile cases in recent ICJ history, South Africa versus Israel, Professor Benvenisti served as a legal counsel of Israel in the preliminary measures stage. He's been a co-editor of the British Yearbook of International Law and served on the editorial board of the American Journal of International Law and was founding co-editor and editor-in-chief of Theoretical Inquiries in Law. He is a recipient of several prizes, including the Humboldt Research Award and the Francis Deak Prize. From 1994 to 1998, he served the International Law Commission of the United Nations and is an associated member of the Institut de Droit International since 2011. He is a member of the Israeli Academy for Sciences and Humanities and the Venice Commission of the Council of Europe. Professor Benvenisti, it's an honor to have you.
Thank you for this kind introduction.
Let's dive right in. Professor Benvenisti, how did you experience October 7th? And from your perspective, how has that day changed Israel since?
So on October 7th, I felt as if I was personally violated, as if my partner was violated, as if my kids were attacked, because the attack was perpetrated against any member of the Israeli people, any Jew, also non-Jews that were around, and so I realized what is the meaning of crimes that are committed against people, not because of who they are, but because of who they belong to, and that was a really frightful feeling, and something that still persists in the sense that people are concerned. People in Israel are concerned and also are motivated to enhance their security. So, and I think that was the intention. The intention was not only to inflict pain and suffering, but also to drive the message that any Israeli, any Jewish person, is not safe in Israel, and obviously also not safe outside Israel. So, and so that was really a terrible feeling that was felt, I think, throughout Israeli society at the time, and since then it still persists.
Yes.
All right. October 7th has been described as the most horrific massacre against Jews since the Shoah. From an international law standpoint, what do these atrocities constitute?
Yeah, so this is really a difficult question, and it's a good opportunity for me to try to explain the way I see things. So from the perspective of international, there are three types of crimes. There are war crimes, there are crimes against humanity, and there's genocide. War crimes are crimes committed against, for example, against individuals in violation of the laws of war. So, if under the laws of war you may not target civilians because they don't take part in hostilities, then there is a person who does so commits a war crime, and it's like it's a crime under international law. It is prohibited, and one may be subjected to life in prison for that. Then there are crimes against humanity. There will be specific crimes committed in a widespread and systematic way. So it's not only a matter of one soldier who kills civilians. It's a matter of a plan, a systemic and widespread plan to, for example, kill, maim, and harm, for example, civilian population. That's also a significant accusation and a heinous crime. Third, there's genocide. Now, genocide under the Convention on the Prohibition of Genocide is defined in a rather strict manner. It's not only the destruction or the killing of a population, it is a crime perpetrated against a specific group as such. So there has to be a special intention to destroy the group as such. And that has been interpreted by the International Court of Justice and by the other international tribunal as demanding a very high standard of proof. One has to prove genocide. One has to demonstrate an intent to destroy the protected group. So if you take the Hamas attack on October 7th, what was their intention? Was their intention to kill civilians and terrorize the population? Probably yes. Was their intention to destroy the Israeli or Jews as a group? You have to demonstrate that intention. One could argue that that's the case if a Hamas official is interviewed and he says there'll be not one October 7th, there are going to be a million October 7th. That's an intention to destroy the protected group as such. To the extent that intention can be proven in each and every individual case, that's a different undertaking. So I'm not sure that was the intention of the Hamas on October 7. Maybe the intention was just to terrorize. Yeah. The point I want to make, though, and it will be relevant also in context of Israel, is that even, only killing, only committing war crimes, only committing crimes against humanity is already awful enough. So, focusing on whether or not that a specific act is an act of genocide or not, in a way, it's a bit I wouldn't say diverting the attention to whether or not an act of genocide is committed. It's a way of maybe undermining or playing down the moral and legal weight that is associated with simple, so to speak, war crimes or even crimes against humanity. These are sufficiently horrendous acts and must be punished and must be stopped. It's a long answer to a short question. I'm sure that some of the Hamas people had this genocidal intention in mind. I don't know whether it's possible to prove it to that high hurdle, the high threshold that the courts have adopted.
Some legal scholars argue that Hamas may have crossed the threshold of genocidal intent to destroy a group as such, quote, in whole or in part, unquote. Do you think this legal threshold was crossed?
So that's the question. On October 7th, I did think that was the case. And you can see the GoPro, videos showing the just unspeakable crimes committed, and there may be only one justification or one explanation, not justification, of course, but one explanation for that. The explanation, which is that the perpetrators did not regard the victims as human beings, as worthy of living, and they did not regard them as worthy of living because they were Jews, and they intended to destroy them as such. But it's always the question whether they did it because they were intoxicated or because they thought that this was the way to drive away the Jews from the border or from Israel entirely, which is not necessarily destruction of the group as such. It's not clear, for example, whether ethnic cleansing, as harmful as it is, as a war crime as it is, as a crime against humanity as it is, would also be regarded as genocide if, for example, the intention of ethnic cleansing was not to destroy the group as such, but to secure a place where better security could be provided to the other group. What I'm saying is that we are dealing with levels. We are living. It's kind of trying to regulate hell. We're living in a hell, and in hell there are different levels of criminal activity. But even the higher level of criminal activity is horrendous enough to be prevented and to be punished, and so sometimes one wonders whether law has to be to get inside that level of health and regulate which stage. Are we in -10 or -9 or -7 of hell? I think -1 is sufficiently harmful that must be stopped.
Israel had, of course, the right to defend itself. How do you feel about the development of Israel's military response from a legal, political, and humanitarian standpoint?
So on October 7th, October 8th, I thought that Israel had the right to defend itself. I thought that it was important for regaining trust in the state and in the two-state solution, that there are going to be two states living side by side, that the border is secured and people are protected. And so attacking the Hamas, I think, was a legitimate act of self-defense. There are two questions that arise. One question is what is the response? And whether the response from a legal point of view is necessary and is proportionate. And another legal question is whether the war itself is necessary and sufficient. To the extent that additional acts of warfare would not provide more security, the right to self-defense has been extinguished. So I think that over time, two questions arose with respect to Israel's response. One question was whether the means of warfare that Israel used were compliant with the laws of war in terms of necessity and proportionality in protecting in the context of the harm caused to the Palestinian non-combatants, the Palestinian population. And the other question was, and now is gaining more and more attention, is whether it makes sense to continue fighting because maybe there is no need for an extra measure of security beyond what Israel has already secured. And so the right of self-defense has been used, and now there's no more justification to use it. So these are the two worries that many people have.
Moving on, you served as a legal counsel of Israel in the preliminary measure stage at the International Court of Justice in the South Africa versus Israel case. What were your impressions of those proceedings, and how would you interpret what has come out of them so far in legal terms?
Yeah, so I agreed to act as a legal counsel for Israel in these preliminary measures, and there were a couple of reasons for that. First, I thought that at the time the Israeli response was in line with international law. There were at the time some statements by Israeli officials that could be interpreted as incitement to genocide, but I thought that they did not really had any impact on the military and on the battlefield. And I can elaborate on that if you'd like. And the other reason was that the South African case actually presented Israel as a genocidal project from day one. So from 1948, the state of Israel had a genocidal plan that is now only implemented, but has been perpetrated throughout the years, and that Zionism was actually a genocidal plan. This was something that I thought was a libel and had to be defended. What the court did not do was to issue injunction against the continuation of the Israeli response, because ultimately Israel, in that proceedings, committed to complying with the law. But what it did was to provide preliminary provisional measures on the basis that there is a plausible case or plausible concern that the rights of the Palestinians are affected, that plausible case for genocide. And that was taken by the public as an affirmation that what Israel was doing was plausibly perpetrating a genocide. And this was a complete misunderstanding of the court's position, because, as I mentioned earlier, the court's view on genocide is very, very strict. And according to the court, if you can explain the motivation of the perpetrator in any other way, then you cannot really prove genocide. So the demand for proving genocide is extremely strict. Yet, in order to provide preliminary provisional measures, the court has to accept there is a plausible case, and in that procedure, the court takes a very low standard, a very low threshold for determining whether an act of genocide has been perpetrated, in the sense that if one could say that they think that there is an act of genocide, that would be enough for the court to find a plausibility for genocide. So, in a sense, it's 180 degrees opposite to the approach when it comes before the court in the substantive stage, when you have to prove actual responsibility for genocide. The court is very lenient on the provisional measures, very, very lenient, but that was not understood by the public at the time, and I can understand that people were worried about the situation in Gaza and wanted to protect the civilian population in Gaza, and thought this would be the way to protect them. But that was a misunderstanding of what the court has said in that case, in that proceedings.
As a follow-up, Justice Aharon Barak, Israel's ad hoc judge for this ICJ case, voted in favor of two key provisional measures: the injunction against incitement to genocide and the call to allow unlimited humanitarian aid into Gaza. Why are these two measures so important, and how is Israel, from your point of view, performing and complying with them?
So these are extremely important measures. First of all, because you want to protect the population. You don't want. You want to ensure that they are protected, that they have access to food, to medicine, to water, to sanitary conditions, and that they are not being targeted. Now, once the court found that it has jurisdiction issuing that type of order is a no-brainer. I think it is, and this is what was in on Justice Barak's mind. That you want to make sure that the population is protected. Even this is anyway what the law requires. So there's nothing that the law requires that is not mentioned in that provision. Similarly, the obligation to prosecute calls for genocide, incitement to genocide. This is basically what the law requires, and you want people to be mindful about the harsh consequences of issuing such statements, especially if you are a leader, if you are a person who with authority, with influence. You don't want soldiers to be influenced by such acts. So I think it's only humane to emphasize what the law requires in any event, and to what Israel committed itself in any case in those proceedings. I mean, I must mention that in the Israeli statement before the ICJ, Israel made a declaration, a binding declaration, that its judicial authorities will prosecute any violation of the Genocide Convention, including incitement to commit genocide. There was a commitment to doing so.
Mm. Leading Israeli politicians have made statements that South Africa's legal team cited as evidence of incitement or proof of genocidal intent. For example, Yoav Gallant, the former defense minister, compared Gazans to, quote, human animals, unquote, and called for a total siege. How do such statements factor in legally?
Yeah, so the Israeli response, and I think it's also my response in that proceeding, was the following: there could be members of the parliament, the Knesset. It could be members of the cabinet who would issue all sorts of statements that are immorally illegal and should be prosecuted, but that does not affect the way the army operates. The army, according to the law, receives its orders from the cabinet in its entirety, and the army is also in a position to refuse complying with manifestly unlawful orders. Ultimately, this was Israel's response at the time. Israel is or was a rule of law state. There were with judicial independence and with independent attorney general, and who was ready and willing to prosecute any criminal actions. So the fact that Yoav Gallant and others have stated such statements that are irresponsible and probably illegal doesn't mean necessarily that this has any effect on the army itself. So this is one thing. The other thing is that if you ask Gallant, if you ask Netanyahu later, what was your intention? Now they will say, no, we didn't mean the civilian population. We meant Hamas. We meant not all Gazans as human animals. We meant Hamas. and only Hamas as human name. You can. The problem is that you can manipulate your statements a priori and after the fact, and that's very, very difficult to prove. And this is why one has to respond very aggressively to such statements. Unfortunately, and I must say unfortunately, some members of the Israeli Attorney General's office thought that because Israel is a democracy and has free speech and so forth, one does not have to respond to each and every statement using criminal law. My own view is that was mistaken, and that you should respond very, very aggressively to a statement that could have somehow influence ultimately on the battlefield.
World-leading hunger expert Professor Alex Deval described the current humanitarian situation in Gaza as, quote, the most minutely orchestrated man-made starvation, unquote. He's seen in 40 years of research on starvation because it could be instantly halted by a single decision of Prime Minister Netanyahu. Legally, what obligations exist to prevent such outcomes? How do you assess the aid situation and starvation in Gaza?
So, what I know is from the media. I have no private knowledge or information from people on the ground. So what I will say must be qualified accordingly. I think that Professor Deval is exactly right when he says that starvation is occurs, and it's a crime that must be stopped. I think that the decision sometimes in March to stop the provision of food through trucks, etc., was a disaster. I think that the implementation of the alternative, the so-called GHF or whatever, Gaza Humanitarian Foundation, is in itself unworkable plan that could have been known in advance, and only makes the situation worse, because the least able people are not able to benefit from it, and so there's no doubt that what's going on is must be stopped. And I think that again, from what I hear, what I read, is that since there was an inflection point, I think 2 weeks ago, and since then the Prime Minister realized that they have to start providing food as much as they can to the entire population of Gaza.
Yeah. The Gaza Humanitarian Foundation, established in 2025 to distribute aid instead of the existing UN structures, has drawn criticism. Doctors Without Borders called its distribution system one of, quote, orchestrated killing, unquote. Do you share legal, political, and humanitarian concerns about its operations?
I think that experts have warned about this plan at the outset, and simply I can't understand what led the designer of such a terrible system to operationalize it. I mean, it allows those who can grab as much food as they can and take from others, and so the powerful get the food that they have in any event. And think about the elderly, think about the younger people, think about the parents who have to provide for the kids. How would they travel certain kilometers in the heat and the sun and fight over boxes of food to carry them over certain kilometers back? And the same goes for the parachuting of food. It's also an unworkable system. There's no way except having a coordinated effort with the international agencies to bring food to those who need it. And any unilateral measure is doomed to fail.
You've legally criticized the plan to concentrate roughly 600,000 Gaza residents into a so-called humanitarian city under an operation called Gilead's Chariots, built on Rafah's ruins. Could you explain this initiative, whether it's still on the table, and why you believe it potentially amounts to a war crime or a crime against humanity?
Yeah, so there was a moment where the cabinet, it was said in the news, and people did not deny that there was a directive to the army to develop a plan that would include the concentration and the movement of the population as a goal in and of itself. And the army actually hesitated. And together with a colleague of mine, Professor Chaim Gans, who is a legal philosopher, we issued a statement saying that the army should not abide by such an order, that would be a manifestly unlawful order. And I think the army resisted. And there was a lot of critique inside Israel about that plan. And ultimately, you don't hear about it any longer. Instead, what you hear about a new plan that the army also resists, a plan to conquer Gaza or to occupy Gaza, as if conquering or occupying 75% of the strip is not sufficient for Israel's safety, and you need to take control of the remaining area, and the army resisted, or according to the news, resisted because it would not improve Israel's security. It would not release the hostages, and the way to release the hostages is through negotiation, not through, according to the army, not through fighting. And that means that there is no more right to self-defense, because the additional benefit that would to Israel that would derive from the occupation of the rest of the Gaza Strip would not, according to the expert, who is the chief of staff, would not add anything to Israel's security. And so there is no reason to continue the armed conflict. I think what we see in the last couple of weeks is a growing tension between the political institution, which is the cabinet, headed by Netanyahu and some other members, and the professional army that resist. They resist about the humanitarian city, and they now resist the additional front in Gaza.
After disturbing and heartbreaking images of abused and starved hostages Eviatar David and Rom Braslavsky, Prime Minister Netanyahu announced intentions to occupy the entire Gaza Strip. From legal and political angles, how do you assess this? What has been the reaction among hostage families, civil society, and senior military and intelligence figures in Israel?
So we're talking on the 14th of August. On the 17th of August, Sunday, there is a plan to have a 1 day of strike, general strike in Israel, and the people who organize the strike are the families of the hostages, the remaining hostages, most of them remaining hostages. So it means that from the perspective of the families of the hostages, the occupation of the rest of Gaza would not bring the hostages back. From the perspective of the army, it would only create more risk to soldiers and more challenges to the army, and of course no safety to the Gazans themselves. So you see the professional echelon within his Israeli army opposing the plan. You see huge swath of Israeli public against it. Whether it will be an inflection point or not, I doubt it, because the government is now controlled by extreme right-wing parties and a prime minister who does not want to end the fighting for his own reasons.
Moving on. According to a recent Faz article, the genocide debate has reached parts of Israeli society. Additionally, in the broader global Jewish community, voices are critically reflecting on these issues. Earlier this year, Omri Böhm warned not to conflate the legitimate legal investigation with a political campaign aimed at delegitimizing Israel. What are your legal and political reflections on this discourse?
So I think that going back to the question that I answered at the outset,
Yes.
I think it's from a legal point of view, a strict legal, strictly legally, I think it's very hard to prove genocide in terms of intention to destroy the group as such. And the problem that I see is the following: the legal definition is very demanding. Yet there is another aspect which leads many people to be concerned about the situation. What they see is disregard to Palestinian lives because they're Palestinians. Looking at group membership, group affiliation as a reason to regard people as not worthy of having the same right to life. That's despicable. That's what many people act as if that's for them is right. That's immoral. That's illegal. Whether that's amounts to genocide. Again, we live a couple of floors below in hell, where there's one person says, "Well, I don't think members of the other group has a life worthy of protection, but I don't really care if they remain alive or not." The other said, "No, I want them to be dead. I want them to be exterminated because they have to be removed from Earth." You see, we're talking about two criminals. Who is more despicable than the other? It's in a way it's beside the point, because both of them must be stopped. I think that if you start asking, no, if you only want them, if you only don't care about them, no, then fine, you can lead your soldiers into the battlefield. No, I want those who feel that the enemy civilians, the other side civilians have no right to life, I want them to be removed from the battlefield. I want them to be thrown to jail. If you see what I mean.
Yes. France, the UK, Canada, and Australia are planning to recognize Palestine as a state. What do you think of the potential legal and diplomatic implication, and what is your view of it politically?
So many countries have recognized Palestine, and so you ask yourself, what difference would it make if other countries recognize Palestine as well? You can already read reactions within Israel. The same right-wing leaders saying, no, now, because the Europe is going to recognize Palestine, we need to act fast in order to create facts on the ground and to undermine the possibility of a two-state solution. So I'm not sure it's helpful or not. I'm not sure if it's helpful or not. I think that according to the International Court of Justice judgment from last summer, July 2024, all states have the obligation to assist the Palestinian people in regaining their sovereignty in the West Bank and Gaza. So there is an obligation to deliver a two-state solution according to the borders of the pre-67 lines. And the question is, what is the best way to implement or to accept that obligation? I'm not sure that recognizing will have any effect, but one can never know.
The US has sanctioned the ICC, and Germany's Prime Minister Merz invited Netanyahu despite an ICC arrest warrant. Moves widely criticized as assaults on international law. What is your take on these developments?
So I think that the US has complete right not to engage with the ICC, but to impose sanctions on ICC judges. That's too far. I think that the ICC is an important institution. One hopes that it acts in an independent and impartial manner. And the ICC in that context is subject to monitoring, so that people will be able to see the extent to which it does operate in an impartial and independent way. Now, having said that, I think that leaders have their own considerations that they take. I, for one, would prioritize rule of law considerations to political motivations.
You protested Israel's planned judicial reform. Could you explain what happened and why a fully functioning independent judiciary is so crucial right now?
Yes. So when Israel argued before the ICC, International Court of Justice, and the case brought by South Africa, Israel said that there is no need for provisional measures against Israel because Israel is a functioning democracy. Israel has a robust rule of law system that ensures compliance with the law, independent courts, independent attorney general, and prosecution, and so Israel will be able to deal with violation domestically. Now, if at the same time the government tries to undermine judicial independence and undermine the impartiality and the independence of the Attorney General, and restricts democratic rights, then what is left from that promise? So, in a way, the so-called judicial reform, which is essentially a legal revolution by the government, operates to relieve the cabinet officials and military personnel from legal responsibility under Israeli law. Because if there's no prosecution for war crimes, there's no prosecution for incitement to genocide, then people can do whatever they want, realizing that the prospects of being brought to justice, the ICC, are remote. If you remain in Israel, nothing will happen to you. So there is a deep connection between the planned judicial reform, as you called it, and concerns about what's going on in Gaza and other places, West Bank.
Mm. Are there any active legal attempts by Israeli courts to investigate the Gaza military operation? If so, what is their status, and how might these proceedings potentially affect the ICC's jurisdiction?
So this is this is a big question about what's going on internally. Are there any prosecutions within the military system, legal system? We don't know about them. We're being promised that there are things going on, that there are investigations, and that they await further information, and so on and so forth. And there's a big question about commission of inquiry that's supposed to be established. Now, these are all remain to be seen. The fact that the war is ongoing, in a way, put a lot of pressure on the court not to intervene, in order not to undermine the military effort. People are saying, we can't have every general prepare themselves to investigations and to commissions of inquiry and to court proceedings, because now they have to fight. They have to concentrate on the mission before them. And there may be that, in and of itself, maybe another reason why the war is prolonged, is being prolonged for so long time.
You are an internationally leading authority on the laws of occupation. Can you explain the ICJ's advisory opinion on Israel's occupation of Palestinian territories, what it found, and what actions it called on Israel and the international community to take? How does this compare with the current situation in the West Bank?
Yeah. So, the opinion from 2024 was rather straightforward. It said the occupation must end now. Israel must return from withdraw from the occupied area in its entirety, and other countries must do what they can in order to implement that plan. I think it was significant that the court defined the Palestinian territories in a way that implicitly, almost explicit, but obviously implicitly recognizes the green line or the pre-67 line as the line of the Palestinian territory. So a two-state solution is being endorsed by the court, and that's significant for those of us who have studied the legal aspects of the Israeli-Palestinian conflict. This is closest to a recognition of Israel's right to exist within secure borders in the pre-67 area. So a two-state solution. That's the in a way the deal that the court is suggesting. Now the problem is that there's significant political pressure within Israel against that, and there is a minister, Bezalel Smotrich, who since day one of this government implements a plan of forceful annexation of the West Bank and now also Gaza. And so there's utter disregard of what the court has said. So if you read the court opinion, it's so much removed from actual reality, both in the West Bank and in Gaza right now.
Amnesty International and Human Rights Watch have accused Israel of implementing an apartheid regime, extending to Israel proper. What do you make of these accusations, and does the West Bank situation legally constitute a, quote, form of apartheid, unquote, as historian Benny Morris has suggested?
Yeah, so again, it's like the question about genocide. I don't know whether the term apartheid is useful or not. What I and others have documented is a legal situation in the West Bank. There are two legal systems: one for Jews and the other one for the Palestinians. And the Jews behave as if they are part of Israel, so they live as if they lived in Israel, even though their towns and municipalities are in the occupied West Bank. And that leads to discrimination in terms of services and in terms of the protection by the Israeli army. We hear about attacks by settlers, attacks on Palestinian civilians in the West Bank that are not prevented by the army. That the army does not protect the Palestinian population. So in this sense, it's not only two legal systems, but one legal system that dominates the other. Now, the response against the accusation of apartheid is that the justification for the two systems is not based on race, but based on sense of security, because the Palestinians are more dangerous. They pose a risk to the Jews and not vice versa. Unfortunately, now what we see is that the risk is being posed by the Jews against the Palestinians. In terms of Israel proper, I would beg to differ. I think that despite formally, the recent basic law that recognized the Jewish nation as so-called, I would say, owner of or sovereign in Israel. Actually, there is equal opportunities in many contexts. So many of my doctors are Palestinians. Colleagues in the universities are Palestinians. In terms of individual experiences, if you visit cities like Haifa or others, you can sense ability of people to live side by side, or not only side by side but intermingle. So it's more complex, much more complex and refined than simply a simple accusation of discrimination and even and beyond it, even apartheid.
What is your assessment of the 12-day war with Iran from legal and a political perspective?
So from a legal perspective, there are two questions. Again, one was a right to use force against Iran, and the second, whether the force was used according to the law. So the first question would be answered by the question of whether Israel had was justified in perceiving itself under threat, and that threat was sufficiently immediate to justify a necessary and proportionate attack. Some people say, well, the war against Iran was already ongoing, so there is no need to demonstrate a right to self-defense. I think it's wrong. I think that you need, as I mentioned earlier, you need to demonstrate it. You have the right to exercise force, use force at any stage of the fighting, even if the war has already started. Started by proxies like Hamas and Hezbollah. Doesn't matter. You have to prove it in any case. In terms of necessity and proportionality, one could say that there was a serious risk, not only from the weapons of mass destruction being developed or planned, but from the capacity to strike with missiles, when there was clear intention to develop sufficient capacity to incapacitate Israel with a surprise attack. So that's one question. The other question with respect to the use of force, most of the targets were legitimate targets. A couple of questions with respect to the scientists and to certain targets like the prison that was attacked. So I don't have direct information about it, but if the scientists were actually involved in a plan and they were part of a plan to develop nuclear weapons, they might be regarded as civilian taking direct part in hostilities, and as such be regarded as combatants, and therefore lawful targets.
Finally.
Yeah.
Finally, Professor Benvenisti. As a closing segment, what is your hope? What should the immediate goals be, and how do you envision the mid to long-term path toward resolution, accountability, and peace? What role can international law play, and what are the key factors to watch right now?
So there are two things. First of all, international law does provide the guidelines, and I think we were provided by the Court of Justice in the opinion from last year. And I think the other consideration is the realization that there's only so much that fighting can provide. that the limits on power, limit on the use of force. The Israeli army already says enough is enough. It's only some members of the government that insist on continuing this war effort. Once the two sides realize that fighting will not get you anywhere, and I think if there is one hope from this dreadful war that goes on for almost 2 years, is that Israel will not be annihilated by force, and the Palestinians will not be annihilated by force. And so both sides need to realize that they have to come to terms about recognizing each other as legitimate peoples living side by side, and then international law could provide the guiding light of how to get there, how to get from this realization that war is only destructive to a functional cooperation between two peoples.
Thank you so much, Professor Benvenisti.
Thank you so much.
Is there anything you would like to tell our listeners as a final message?
Yeah, I hope that I was clear enough, and I just wish people to develop their views based on enough interrogation and research, and ultimately knowledge. And I think this is why I think so highly about your project, because it does aim at providing information that would enable people to make a responsible statement, a responsible take on this terrible situation.
Thank you so much. With that being said, this marks the end of our podcast. Thank you for your extraordinary insights again, Professor Benvenisti, and it was an honor and pleasure to talk to you.
Thank you for listening. If this conversation was meaningful or unsettling, if it left you with answers or more questions, feel free to like, share and subscribe. See you next time on our Israel-Palestine podcast.